start studying it. So they're largely unhelpful. So this is actually probably for your advantage. So I'd like to know is what day during the finals period do you think having a review session would be most advantageous? Wisdom of the crowd. So start off, what's the day of your property exam? I should know this, but I don't.
16th.
Okay, the 16th. So it should be something before then. What's your previous exam before property? On the 13th?
13th.
Which one is it?
13th.
So you have one on Friday the 13th. So you have an exam on Friday the 13th, and then you have me on the 16th, which I guess will only leave a weekend, and I don't think anyone wants to do that.
We have a huge break after contract. It's like almost a week.
What day is that?
The 7th.
No, contract.
Okay, well, we can try this. So Saturday the 14th. A show of hands. Who would want that day?
Why can't I do it like now?
Well, I can do it during the semester, or I can do it when you actually have to study for the exam. That's what I always have this conflict with students. It makes no difference what day it is. Maybe I can come whatever day is most convenient for you. All right. So so you said you have. Do you have anything on the 9th, 10th, or 11th? Okay. So I think I can do it those days. So what if I do it? Okay. Show of hands if the 9th, 10th, or 11th, that period would be better for you. Okay. So among those days, let's just say, so among the 9th, 10th, 11th, the 9th, 10th, 11th. Okay, so no one had 10 or 11, no one had 11. Mondays and yes, calendars. Mondays at 9, and Tuesdays at 10. Okay, so what if I said 9 a.m. on Monday the 9th? Okay, that's it. 9 a.m. Monday the 9th. Okay. Yes, sir. So the way it's going to work is like this. Okay, so I'll put this on I'll send you guys an email later to confirm this. So I always this in class. It takes a few minutes to work this through. So Monday, 9 a.m. On the 9th of May. So the way I'm going to work this is I will have for you printed out one of my old exams. I don't know quite which one yet. I'll tell you at some point, and I'll have it printed out, and I'll proctor it. I'll give it to you under normal testing conditions. I'll say, okay, right at the time on the board, you may now begin, and then you'll have a full 90 minutes. I won't give you a full 3-hour exam because that'll take too much of your time. I'll give you one of the questions, so 90 minutes. And then after that 90-minute session, I will then immediately go over the A+ answer. So it will be fresh in your minds, and then you'll have hopefully a significant outline. One second. If you want to take the question in advance, you can. You don't have to come here. So I'll start at roughly 10:30 or so going over it. So if you just want to take the question at home or the library, I don't care. I'm not going to be looking at these. But this is for your advantage. And I encourage you to bring whatever any sort of questions you have, and then you can ask me during the review session. I'll stay here as late as you need me to stay here. I'm actually giving a Conla review that afternoon, so this works out. So I'll be here all day. So if you want to come by afterwards, you're welcome to come talk to me. And I'll stay for as long as you need me to be there for you.
We just slip in. You wouldn't even notice.
I'm not going to answer that question. I'm not going to answer that question. You guys are trying to get me in trouble. You really are. Yeah.
Did you say you were going to post a video of the review?
Yeah, it'll be recorded. I encourage you to come so you can ask me questions, but if you can't for whatever reason, I'll put the video online. Okay. Oh, yes. Sorry, I didn't see you in the corner.
Last Thursday, you said that we were going to do the spring 2013.
Yeah.
Exam question 2.
Yeah, I think that's when I'll do.
Okay.
If that's what I said, then that's what we'll do.
I wanted to do something ahead of time before coming
Yeah, so I said spring 2013, the second question. That's what I said? Okay, then that's when I'll give. It's been a long week. Okay, yeah, thank you for reminding me. I appreciate that. So spring 2013, question number 2. Although I encourage you more generally, take every exam I've ever given. Not all professors post their exams. I do. And the reason why is I don't want you to ever be surprised for anything. There will be no surprises. I am fairly predictable. The fact patterns will always be demented for certain, but the types of questions I ask are not. And this will at least help you prepare and get on the right track. I found year after year the kids who get A in this class have taken the bulk of the exam questions that I've given before. There's not a mystery here. You can look at Gilbert's or flashcards, whatever the commercial questions, but I'm actually giving you, like, at this point, 10 or so questions to consider. It's time consuming, right? Each question will take you about 90 minutes, give or take, so there's a lot of time. But if this is something you really want to get an A in, then I think you'd be well served to go through them. And don't wait till the 48 hours between your con law exam and your property exam. I would not wait for that period because it won't be nearly enough. Okay. Yes.
The spring 2013, it's the fall, like the fall is May 2013. So I don't know if are we going by the
Yeah, spring 2013 is May 2013.
no, and like you click in it, the full one. If we want to do the full one, for example, not to do the one that we're going to do in class, the full one says May 2013. So just
I don't understand your question, but May was in the spring, right?
yeah, but it's labeled full. So the spring is labeled.
Did I put the wrong label on the syllabus? Is that what you're saying?
Yes.
Well, I can fix that. Okay, let's see.
So
Did I fixed it? Okay.
well, that's the question. Sorry.
Okay, well, if I fix it, then I fixed it. Knows that I actually corrected a mistake. It happens. It happens.
And you gave the download link as well.
Wow, you're good. I honestly, I don't remember here. Spring 2013. Okay, and the syllabus is right there.
Oh, no, it's the full 2013 page.
Do I ask after class?
Sure.
Okay, if it's a problem of a bad link, that's really easy for me to fix. Spring 2013, property 1. Yep, May 2013. And then the second question involved Jersey Shore, which I was a fan of, but unfortunately people don't know about as much anymore. But yeah.
Sorry, just to clarify, are we doing 13 or 2013 or 2014? Because the email says 14.
It's not a big
Yeah, we can do
Jacqueline, did I say 14 or 13? I don't remember now. I'm
it.
confused.
Class is at 13.
Oh, in class it's at 13, and email is at 14. Okay. I'm glad I get my evaluations before this little flub. Okay, so I'll send an email to clarify, but we will be doing spring 2014 second question, and God willing, the link that's actually correct. Glad we got that straightened out. I mean, we sail through rule against perpetuities, we sail through future interest, and I get screwed up on what year I'm giving a question from. The easiest part of the entire thing. Okay, so yeah, this is the one I wanted you to do. It's a spring 2014. Okay. Good. Glad. We good? Very good. Okay. Any other questions about that? Anyway, whatever year they're from, do them all, and that way you'll have no excuse. You'll be fully and adequately prepared. I want all of you to do well. I think I told you did better than I expect in the midterm, so I hope that you keep that up. Okay. So we only have 2 classes, and today's class will probably be shorter than average with this delay of the evaluation thing and trying to figure out the dates for this midterm, a final exam. So what I want to talk about is landlord-tenant relationships. And we began this discussion what feels like forever ago with our discussion of what happens when rent is not paid. Right? What happens when the tenant breaches the conditions of a lease? What remedies are available for the landlord to help resolve those disputes? and we discussed this idea of self-help. And the courts have more or less held that self-help, that is going in, changing the locks, throwing the bum out, right? That is no longer an adequate remedy at law in the event that there's a dispute over a breach or whatever. And the reason why is that often the landlord is not the most, shall we say, objective person to determine whether in fact the lease has been breached. Indeed, the landlord always has an incentive to perhaps, shall we say, exaggerate how bad the condition is. This has been a theme throughout much of our discussion, and it'll bleed into today. In the modern regime, the courts have taken a very skeptical view of landlords, and they've made it perhaps increasingly difficult for them to enforce their leases strictly. And our discussions for today continue that. Okay, questions? So the first topic to discuss is something that probably you're all very familiar with. And these are what are known as security devices. Has everyone here paid a security deposit on an apartment? Yes, we all have. What you may not know is the origin of these deposits. I mean, they are basically there to ensure that in the event that the tenant breaches, the landlord doesn't get screwed. You can imagine in the era of self-help, if for whatever reason the landlord had a problem, he could just throw the guy out and put someone else in the apartment. But due to the lengthy time it takes to eject someone and throw them out, there's often going to be the case where the landlord does not actually get paid. So the deposits are there to ensure that if there's back rent due or any damage to the property, it's covered. Okay. Most jurisdictions put fairly strict limits on security deposits. So, for example, most jurisdictions limit it to only 2 months' rent, the so-called first and last month rent. These security deposits must be put in what's known as a trust account. Now, what does it mean to be in a trust account? It's separate from the landlord's general bank account. In other words, that money has to be protected. The landlord can't use it to pay its bills or whatever else. It has to be secured, and indeed it has to earn interest, an amount so small and negligible that it doesn't even matter. But the idea is this is not a way for the landlord to profit. Because you can imagine if the landlord put all these security deposits in one account, it would actually give him a profit, all the interest that it would accrue. Okay. It cannot be commingled. Commingling is an idea that you as lawyers will soon have to know very much about. I think I told you this before, but the number one rule of being a lawyer is getting paid, right? You need your money. Often, the way lawyers ensure they get paid is by having what's called a trust account or a retainer, as you may have heard. The way a retainer works is you say to your client, okay, my rate, easy, $100 an hour. I want you to prepay for 10 hours. So basically, you write you a check for $1,000, $100 an hour times 10. Each client that you have has a separate account. Now, banks can rig this up. You don't need actually different banks, but they can, within one bank, a separate trust account for each client. And that $1,000 stays within that client's amount. You cannot use it for any of your other client matters. You can't withdraw from it until those bills are performed. So say if in the first month you bill 5 hours, okay, then you withdraw $500. Then second month you have another 5 hours, you withdraw $500. It counts that to zero. But you need to provide billing and very precise measurements. The quickest way to get disbarred, right? You guys are all here in law school thinking, oh man, how am I going to pass that bar exam? How am I going to be a lawyer, right? The quickest way for you to lose your law license, I'm not joking, the quickest way is commingling funds. The quickest way. The reason why? It's really easy to prove. When it shows that you are withdrawing money from a client trust account and it's not because of a billing matter you did, that's easy to show. The client say, look, he took off $500 to go to Jamaica, right? Instead of paying for my fees. So do not screw up commingling of funds. This is, if you ever, they publish, the State Bar has a journal. They publish every month who's been disbarred. And they usually give like a little blurb or a summary, people nodding their heads. If you look through them, a lot of them are going to be commingling funds. Even with other stuff, like you lied to a court, whatever, you'll get suspended. But you lose your law license when you screw up the funds. That's a biggie. So don't do that. Another aspect of the security deposit, which you don't think of, is that in terms of bankruptcy, right? Say the landlord goes bankrupt. You as the tenant get your deposit back before his creditors get it. This is what's known as priority. You'll discuss this in secure transactions. But when a person goes into bankruptcy, all of his debtors line up. They're in priority. And usually the person who has a mortgage on the building would come first. But before your landlord can pay off his mortgage, all that trust money must be returned to you, the tenant. So the courts and the legislatures have put the security deposit like at the apex, the pinnacle of all manner of money that's owed. And in the event that the landlord screws up with your security deposit, there are various ways to get double and treble damages from it. So this is something which landlords know not to screw up. Has anyone ever had a landlord try and screw them on the deposit and everything? Yeah, what happened? Yeah. That was a logical follow-up, right?
There was really, he's got the medical ones.
Why did he was there any damage or anything?
No, there was no damage.
And did you consider filing claim or not?
I did, and then started the process, and then I had to pledge a little bit.
Yeah, things happen.
It was $500, so I figured.
See, and that's exactly why, right? Because you could have probably gotten $1,000, maybe $1,500 back, but was it worth your time?
I thought it was.
Yeah, it wasn't. Right. So I mean, this is generally what happens, right? So the law provides these very stringent methods of suing for these fees, but if it's a couple months rent, we're talking a few $100s, maybe $1,000, and in your case, it may not even be worth it. But landlords, by and large, do have to fear this scenario. Okay. The book has a little discussion on ways that landlords can get around this. They can perhaps call it a bonus, right? That when you sign this lease, you pay a bonus to the landlord, like almost like a finding fee, right? That does not need to be returned. Advance rent. This is also a situation where you might prepay for an entire year in advance, even though it's a month-to-month lease, or a year-to-year as it's known. You can still prepay, and this ensures that the landlord keeps the full rent. Has anyone ever had a liquidated damages provision? A liquidated damages basically says, if you do this, you owe us X, and then you basically have to prepay the X. These are held up so long as they're, quote, reasonable. Courts don't like liquidated damages. They like damages to be assessed after they happen, not calculated before they happened. Has anyone ever dealt with a rent acceleration provision? Anyone ever had one of these? I had one of these. I didn't even know what it was when I signed it, but then I figured it out later. So the way this worked is, say you have a 1-month lease, and then in month 6 you breach. At that point, the landlord can demand the remaining 6 months of lease immediately. It basically accelerates the duration. So if you breach the lease or you move out early or whatever, you basically owe the entire duration of the lease going forward, which basically makes it impossible to move out early because you're paying for rent of an apartment that you're no longer in. Now, come to think of it, I actually had a security deposit plus a rent acceleration. I got screwed over on that, but I don't think I realized it till much later in life. I stayed through the full term, so it wasn't a problem. And then the weird thing with the rent acceleration is, even if I pay for the full 6 months, the landlord can't take possession. So then the unit would actually be empty for 6 months, which doesn't make a whole lot of sense. But I'm paying for an apartment. I could still be there in theory. I guess I could have someone else live there to landlord consent, but it doesn't make much sense. Yeah.
Can you kick you out?
Well, if I pay the full year's lease, it's mine. But The problem is if there's a breach, right, they can demand the entirety of the lease up front. Or
But
at
they
this,
but they have to let you stay. if you want.
they can't take possession because if you don't pay, they can kick you out. But if you do pay the 6-month lease, the 6-month gap, then it's yours. Again, I don't think I appreciate that when I signed that lease, but in hindsight, I realized it's probably not the smartest idea. Yeah.
I don't understand the rent acceleration clause. Like, why would you ever tell your landlord that you're leaving? Because if your thing is, if your apartment's just gonna be held up, you're gonna have to pay the entire amount. You'd rather pay $1.
Well, it's not just for leaving; it's also for a breach. So say the lease says you can't bring a pet in, or say the lease says you can only bring 2 people in, and the landlord finds out that you brought in a pet. They can say you breached the lease and make you pay up front.
But as a tenant, why would you ever say that you're leaving? You'd rather pay $1 a year.
Well, I mean, the flip side is maybe if you're leaving, your landlord may consent to a sublease, in which case you would not be on the hook for the 6-month additional lease. But your point's well taken. The second you say to the landlord, "Yeah, I want to move out," it's like, okay, pay up. All right. Then you go, well, look, you want the apartment sitting empty, then maybe you work something out. Yeah, I didn't fully appreciate that till much later after I signed it. Yeah, Jamie.
Just to clarify, like if they have an accelerated rent provision, let's say you leave, but you do pay the remaining balance of the rent, and the landlord can't take possession.
Pay it at once, so it's not monthly. You write one check.
You write one check, and let's say you leave. Can that, let's say you move to another state, you're just not around. Can the landlord then, I guess, he has to by law leave it open, leave it vacant?
Yeah, unless he works out a sublease with you, because you're still the lawful tenant, even if you're not there. I mean, there may be an abandonment provision, but generally speaking, they can't take over.
So it just has to, they have to wait. Until,
which is why it's not a very smart provision. Which I don't know why my landlord. I mean, it was a security deposit and a rent acceleration, which makes no sense to have both. But whatever. Yes, Sarah.
So that he cannot take possession, but can he prevent you from being in possession of it in spite of you?
So long as you paid, it's yours.
So you
And
could have 10 people in the apartment and you pay for it, it's yours.
well, landlord leases may stipulate how many people are allowed to live there, and one of the reasons why you may breach a lease is if you have extra people living there.
Right.
But in general, if it's yours and he doesn't let you in, it's an eviction, and then that's like the case. What?
And then if he evicts you, then you don't.
Yeah, I mean that's like the case we'll do in a few minutes. Yeah, I'll go back to you. Yeah.
Okay, so let's say you breach, you do pay all of it, and then you just continue breaching. Can you do anything about that?
You could probably withhold security deposit if it's still there, or you can move to evict you. I mean, the remedy for a breach is always you can move for summary judgment. So that remedy is always available. Okay. Even if you already paid and you're breaching the lease, you can still evict the person. Okay. Jamie?
you answered my question.
Wow, that was good. You guys are on the wavelength. Nice. Okay, any questions on that? Yeah, Jessica.
So in those cases where you have the acceleration clause or covenant, then we don't have to worry about mitigating damages.
Well, in the case I had, there was a security deposit plus acceleration. So even if there were damages, which there were, I have a dog. She took it out of the deposit. So the tenant still has to be on a duty of paying whatever damages he inflicts the apartment.
I was thinking about, and sorry I made it so generic, but I was.
Oh, you mean the
thinking about,
landlord's duty?
The landlord duty.
Oh, I
like,
see.
To mitigate damages.
No,
if
and
you
in
find
fact,
another tenant.
he can't let out the apartment so long as you prepay the last 6 months. He can't put someone else in the unit because then that would be an unjust enrichment. He can't be collecting 2 rents for the same period. But you're right. It's a weird thing with this duty to mitigate because generally the law doesn't like an apartment sitting empty. But with this acceleration provision, that's precisely what ends up happening. Yeah, I think if I remember correctly, my lease ended the day after the Virginia bar. I'm pretty sure that was like I imagine, so I stuck around just till the end. Questions on that? Okay. I don't want you to worry about the anticipatory breach stuff. Did you say that in contracts at all? Yeah. The reading is more complex than it's worth, and all these formulas I don't particularly care about for purpose of this class. But know that it actually does happen sometimes that if the landlord knows that the tenant's going to be moving out, then they can anticipatorily breach it rather than having to go through the entire process. But I'm not too concerned about that. What's that?
Oh, we're bumping feet. Let's see, somehow.
What's that? I didn't hear what you said.
We're bumping feet.
You're bumping fee?
It's not slang.
His
They were
feet
literally
are
bumping
bumping.
feet.
You're bumping feet?
So I was apologizing.
Oh, I didn't even notice.
Apologizing.
But whatever, it's the last week of class. I don't.
It's nothing weird.
Yeah, whatever you guys want. It's.
They're both married, so it's
All right, let's move on. You guys are getting me in trouble. You guys are trying to get me in trouble. Hasn't happened yet, but it'll happen eventually. So let's talk about the competing duties of lease premises. So there's always this tension, right? Once the lease is signed, the landlord has every incentive to neglect the unit, neglect the repairs. Because whatever he neglects, it falls onto the tenant, and that's plus money he has to pay. Okay? The tenant who's actually in the apartment or in the house, whatever it happens to be, has every incentive to fix things. Why? Well, he doesn't want to live in a crappy apartment. But when he bears the costs, unless he can shift the cost to the landlord, the tenant's out of luck because he's paying rent plus his repair costs. So there's this weird dynamic, which I'm sure we've all experienced. So at the common law, the book describes it as, I love this, hard-headed and hard-hearted. And basically, the landlord only had a duty to provide legal possession. There was no duty whatsoever to provide the physical condition of the premise. And we saw this with the case in Virginia last week, where the guy showed up in the first day of the lease, and there was a holdover from the previous lease. And he's like, hey, I'm going to sue you. Let me in. He's like, well, you have legal title. Take care of it yourself. That was very much the mentality of common law. You gave someone a piece of paper saying that you now have a lease to this land. Go deal with it. That was the caveat emptor approach, that the landlord has no obligation to warrant the fitness of the premise. Over the last, I don't know, half century or so, that doctrine has basically vanished. It's no longer the case that we apply a sort of caveat emptor standard for leases. Okay, the courts have now shifted it to put significant numbers of burdens and covenants on the landlord. Okay, everyone's okay with that? So the dispute usually arises in one of two circumstances. Okay, the first is that the tenant wants to vacate. In other words, there's like a problem, the tenant wants to get out of there. Or maybe wants to stay but pay less rent. So how do you deal with that? And the second situation is a tenant might actually be injured by the premise and seek damages. So the first case is where the tenant's either trying to get out of their lease or reduce his rent. And the second situation is a tenant saying, look, this is so bad, you got to pay me. This is not about me paying you less. You're going to pay me for these awful conditions. And I think the primary, in fact, the only case we have today, I think illustrates this sort of situation. So a rule of thumb, if you're going to be a bad landlord, don't do it to the prosecutor's office. You're going to lose. What an awful, awful, awful landlord. I mean, if you're going to screw over anyone, don't screw over the government. I mean, if you notice it was a bench trial, they were not letting this one go to a jury. If you noticed, there's no way to let this one go to a jury. All right, so yeah, no way. I don't have any clue where I finished off last time. Anyone recall? Wow, Crima, you're up next. Thank you. I appreciate your candor. Can you please walk us through the facts in this case, the Village Commons case, please?
Yeah, so the landlord was in the commons and the
see was the prosecutor's office, and they entered into an agreement for, I think 7 years and 5 months, where the first 5 months would be free and then the rent would go up. And basically the landlord, there were a lot of leaks and
Yeah.
the office, and they kept selling the landlord, and he refused to repair because the cost was too expensive.
Good.
So then the landlord, the prosecutor's office ended up moving after 2 years or something, and they want to pay rent, so the landlord would sue to get the rent for the remainder.
Okay, very good. Thank you, Karma. So the facts of this case are, fairly typical, if not for the tenant. The prosecutor's office moves into this building. This is actually a picture. It looks like a very nice building from the outside. It looks even nicer from the inside. But the prosecutor's office occupies the basement, and there are several rooms that they use for storing of evidence. So if I may digress a little bit, one of the most important things that the police department and the prosecutor's office has to do is provide what's known as a chain of custody over evidence. If any of you are ever criminal defense lawyers, you have to make sure that the evidence at all times was following a chain of custody. The reason why is if evidence was not properly supervised at any time, you can raise as a defense lawyer that was corrupted. And once the evidence is corrupted, it can't go to the jury. It's like, maybe someone adulterated it, right? So I have a story that this is actually, this never happened. So when I was clerking, there was a case where this guy was running a meth lab in his, it was a crack lab in his basement. And like he had all these tools and like he had all these microwaves and these Pyrex, which you use to cook the. So crack is basically powder cocaine, and you do stuff to it and reduces it to a crystal, which people can smoke or do whatever else. So there are all these like microwaves and Pyrex glasses and different things used to cook the crack. And he was dead to right. And the guy went to trial, which I couldn't fathom why. He was looking at a huge jail sentence. In every single drug case, usually you take a plea bargain because it reduces your drug sentence. But this guy was looking at a lot of time. He went to trial. And this was something I'll never forget. We were at the trial, and the defense lawyer, this case has been going on for 2 years. He'd been sitting in jail for 2 years waiting for trial. This case was going on forever. And the defense lawyer goes to the detective, where's the evidence? And the detective says, well, we have this picture of all these various, Pyrex and microwave and these various drug paraphernalia. And, the defense lawyer just asks, and where's the evidence currently stored? And the detective's like, he kind of just like, well, I'm not sure. And then the defense lawyer's like, what do you mean you're not sure? And the detective goes, we don't have it anymore. So at that point, the assistant U.S. attorney, the prosecutor, stands up and says, Your Honor, I need an immediate recess, right? And, we take a break. So it turned out that this case began with prosecution by the state police. And then it was handed over to the federal prosecutor, because the Fed likes to take these various big drug crimes. Whoever managed the evidence locker at the prosecutor's office in Pennsylvania, once the case was transferred, he thought the case was over. And he destroyed all the evidence.
Oh.
So all the microwaves, all the Pyrex, all the different tools used to make this crack were just destroyed. So about an hour later, after the U.S. attorney, who had no idea, she called her boss in Pittsburgh, the United States attorney. She's like, we can't do this. So we come back to court an hour later, and the prosecutor's like, Your Honor, we're dismissing all the charges with prejudice. Done. Guy walked out of jail that day. Walked home. Walked home. There was no evidence. What? Oh, if he could do a backflip, he would, but his feet were in chains, so it's kind of hard. Too soon, yeah. But the moral of the story is evidence is really important. So this case, what astounds me is that they were basically keeping evidence, right, that people's life and liberty depends on, in like this moldy, wet room where everything's getting screwed up. And if any of that evidence had been adulterated, right, if the drugs got wet, or if there were paper records that got wet and you couldn't read them anymore, that screws up the case. That's why if you're going to screw over a tenant, don't make it the prosecutor's office, because you're going to lose. Which is why it shocks me how long this entire ordeal went on for. So Ryan was correct. There were leaks basically almost every couple months. I'm guessing whenever it rained. There were leaks. There was mold. There was spotting. You actually had employees who were violently ill in response to this conditions. I mean, I hope none of you had any sort of flooding over this past couple days, but the problem with flooding is actually mold. And when there's wet stuff, you have to rip out the carpets. You have to rip out the wall panel. If you drive up Braeswood by the bio, you'll just see piles of carpeting and wood paneling on the street because they have to rip it up. But what's interesting here is instead of fixing it, the landlord made a number of suggestions. So Jonathan, what was one of the landlord's first suggestions to the prosecutor's office after it became clear that there was this mold by the evidence room?
So I remember they got someone to inspect.
Uh-huh.
And, didn't they say something like replace the drywall?
Well, beyond replacing it, what else did the landlord suggest should be done to prevent this room from getting moldy and wet? What did he tell them to do? It's kind of a pretty brash suggestion.
I guess I don't remember specifically.
You know, Jessica?
He said that not to use that part.
Yeah. He said to go use a different part of the room, right? So if you imagine they leased an entire premise, right? A certain number of square foot. And what the landlord basically said was, oh yeah, just don't use that part where it's leaking. Even though they'd lease for the entire issue, and that becomes quite problematic. So after the tenant moves out, there's still about 4 years left in the lease and almost $400,000. So you can imagine why the landlord wanted to sue to recover the lost rent. So let's take a look at the actual, I have it on the board, the actual key operative language in the lease. And it basically says, in the event that there's some sort of problem, right, the plaintiff, the tenant, can sue for injunctive relief or recover damages. But it shall not be entitled to terminate this lease or withhold, set off, or abate any rent. Serenity, what does this lease provide, this provision? What does this lease actually mean in practice?
But they have to continue to pay rent.
They can't move out. Yeah. What happens if there's a problem? What's their only remedy?
To seek injunctive relief.
What does that mean?
From the court, to ask for the court to do something.
Right. So, exactly. So under the circumstances, under the terms of this lease, the only remedy for the prosecutor's office was to go to court. They certainly knew what the court was. They could go to court and demand an injunction. The injunction would say, hey, landlord, fix this wall, fix this leak, eliminate the mold, whatever it happens to be. And if there's problems due to damages to the office, they can seek a remedy in that respect. But they can't withhold rent, and they can't vacate. And they did both. So, Bianca, why do you think the landlord would have put this sort of clause into the lease? This is a pretty extreme clause. I mean, why do you think this would be put in there?
Probably because he knew that the building had issues.
Oh, good answer. I knew what you said. Yeah, he probably knew. I mean, leaky buildings don't come out of nowhere. He probably was aware that there was a leak, and if I had to guess, he didn't tell them. Often you can't know about a leaky premise until it rains. That's when you find out. So perhaps he knew this was going on. And he put this lease in here otherwise. So anyway, so the tenants vacate, and the landlord files a suit. And he seeks the back rent. Okay. So this issue in the case raises two questions. Right? That of eviction and that of what is known as constructive eviction. Samuel?
Yes, sir.
Please, sir, tell me, what does constructive mean in the law? I'm sure you've seen it in different contexts. What's constructive?
Constructive isn't so much that, as opposed to actual conviction, where you are actually
Eviction, not conviction.
Oh.
You said conviction.
Did I say conviction? I meant eviction. As opposed to actual eviction where you're actually kicked out of the premises. The way that I understood constructive eviction from this case was that they weren't able to use a part of the building. They weren't able to enjoy it as they would have for the lease. And in that sense, they were evicted from the property.
Good. Okay. So generally speaking, you've seen this word constructive in your other law classes. Like constructive notice, sound familiar? Constructive service of process from CivPro, sound familiar? Constructive means not really, but good enough, right? You know, with constructive notice, for example, you put a thing in a newspaper to tell people that there's a suit being filed. Or constructive service, if you can't give it to them, you can give it to their agent, right? This idea of constructive generally means not quite good enough, but enough. So the notion of eviction literally means you throw the bum out, right? You take the key and you lock them away. Constructive eviction, as Samuel said, is less than that. It's less than that. It entails doing something in a manner that the person can't access part of their property. So here, there was actually a constructive eviction when the landlord said, hey, just don't use the room that's wet. Yeah, that's not going to cut it. And what's also interesting is in terms of eviction itself, right? Adam, what was the actual eviction itself? Because he never made them leave. He never made them change the room or the locks. I mean, how was there an actual eviction here also? No, nothing to pay rent. At what point did the landlord here evict the tenant?
Was it in? I remember the constructive eviction was in October when they moved out, and then the actual conviction.
But what constitutes the actual conviction? I'm sorry? I don't care about the date. What did the landlord do just that result in the actual eviction?
Because I know that he didn't allow them to use that portion of the property.
Well, that was a constructive, right? But what was the actual eviction there?
Wasn't it due to repeated unremedied water intrusion?
The water intrusion, right? It's actually interesting. The court considered the invasion of the water as almost like a trespass, right? That they allowed these frequent and repeated invasions by water. And I think the court didn't quite say this, but this was as if the landlord had let some other dude come in all the time. I mean, that's how they described it. So the actual invasion by water of the leaks was the ground on which they found an eviction. Yes, sir.
So it only has to be one part of the premises. So if it was like only one room that they had to evict, then it have to be the entire premises.
Exactly. The idea of a lease is, say there's a 1,000 square foot plot with 5 rooms, you have to access the entirety of it. Think of how we had a situation with the marital property or the joint tenancy, where if one spouse, or one of the tenants doesn't allow someone to this corner of the patch, that's an eviction. That severs the unities. So the idea is you have to, if you own the property or you lease a property, someone can't deny you access to any of it. Okay. Yeah.
Just to make sure I have it clear, it was the recurrent leaks.
It was a what?
The recurrent leaks or the.
What was it? Recurrent?
The recurrent.
Oh, recurrent. I'm sorry.
That's fine. It's my accent. The recurrence of these water leaks that became that actual eviction.
Yes, ma'am.
And when they asked him to not use part of the property, was the constructive.
Exactly right. Yeah. The actual eviction was the water dripping in. The constructive eviction was when the landlord said, "Don't use this room." So in fact, there was both an actual and a constructive eviction.
So just because he suggests not using the room, that's taken to mean as a command to not use the room. Because it seems from the actual quote that it just suggests not using it.
Well, even the suggestion, right, is enough for the landlord to be sensitive, like, wow, I can't use this room.
Well, right.
So I think what the court, well, let me put it this way. Do you think a landlord would demand someone, you can't use this room? I mean, I suppose the landlord could just padlock that room and said, okay, use these other rooms. So I think in most cases of constructive eviction, you have to feel that you actually cannot use that room. Sorry, I'll get you in a second. This actually comes up in the context of employment law, which I encourage, I think I said before, take employment law. It's a very important class to take. Something called constructive termination, right? This is a situation where an employer doesn't actually fire an employee, but they make the conditions so awful that the person feels compelled to resign. In an employment case, the worst thing to do is resign, because once you resign, you give up a lot of your rights to sue. You want to get fired. You don't want to get, I mean, well, there's downsides to getting fired also, but if your intent is to go to court, getting fired is better than resigning. So often what happens when an employee resigns, they well, no, I wasn't really resigning. This was a constructive termination. And that way I was actually fired, and then you can raise these various defenses. Yes, sir?
On the top of page 511 / bottom of page 510, I think that it said that the court said when he said don't use those places, that was actual eviction, and that the water was the constructive eviction.
Did I flip it?
I think so. I mean,
Did I flip it? I may have.
I think the water was constructive, and telling him don't use that part of the.
Oh, you're right.
I understood it the other way.
No, hold on.
It's bottom of 510 / top of 511.
You know, I'm sorry. You're right. My mistake. Yeah, you're right. Okay. No, you're right. You're right. I inverted it in my head. So the correct holding was the telling the words, the actual words themselves, that was the actual eviction. And the repeated recurrences of the water was the constructive. I actually read this very late at night, thinking we would have class on Tuesday until my flight was canceled. So I think I missed it, but then my mistake. So sorry, I appreciate that. Gold star for today.
Oh, thanks.
Okay, sorry about that. My mistake. But the general gist is, even if the facts were otherwise, right? Which is why I think I answered Hunter's question the way I did. Even if a landlord told someone, well, you really shouldn't be using that room anymore, that in and of itself could be viewed in that sense as constructive, because it's not actually saying you have to get out. You're basically strongly suggesting you can't be here anymore. So I think it actually could have been either way, which is why I think I inverted in my head. But the actual water invasions could also be used as a trespass. So the court was right, and I think reasoning it could also probably be the other way as well. But the line between constructive and actual often blurs when there's not a physical eviction, when that person's not physically thrown out onto the street. And that often they'll try and make arguments either way. I appreciate that. Yeah.
If they were looking for a reason to just get out of their lease, or if anyone was, and the landlord said, like, there's water damage, just don't go in there while I look for someone to fix it, there's no way they could like try to say that's constructive. Yeah, that's it.
Well, what could they do? What happens if the landlord won't take them up and take any work on it? What remedies do they have? They go to court. I mean, this is actually one of the issues that probably, it sounds like this is really unfair for the prosecutor's office, but this was a commercial lease, and these were sophisticated parties. The prosecutor's office is staffed with lawyers, and it would not have been very difficult for one of them to go to court, file an action seeking an injunction to enforce the terms of the lease. So while it may seem awfully unfair to the tenant that they had all this water, I mean, they had remedies. I mean, they have lawyers on staff. It would not have been very expensive for them to go to small claims court and to seek an enforcement of the lease. They didn't do this, and then they just walked away because they would probably thought the landlord would never try and collect, and he indeed did. But ultimately, the court bailed them out because of this constructive and actual eviction doctrine. Yeah.
Actual eviction, does it always have to be express, or can it ever be kind of implied?
And this was Hunter's question, right? It doesn't always have to be changing the locks and throwing you on the street. It doesn't always have to be in that respect.
What if they said we've been having some difficulties in general, but
maybe specific.
Let me put it this way. It's going to be harder to prove constructive than actual. The court puts a higher burden to prove a constructive eviction. But if you can demonstrate that the circumstances are such that basically he was trying to get rid of you, then it may actually cross the line from constructive to actual. But the line, and this is why I think I flubbed it before, which I apologize for. The line's often somewhat blurry between the two. The actual eviction of actually going in and changing the locks, that doesn't happen very often. You can actually find eviction on far less than that, which are even words like, I think you should not use this room, even though you're not padlocking it. Right, but the important point to stress is, notwithstanding this clause, the court held that the eviction occurred prior, right? We don't even get to the surrender clause because there's already eviction, and then we don't have to worry about the vacating clause. Yeah.
If they had asked them not to use that room, but they had also lowered the rent, would that have been different?
Well, if they lower the rent, would there be a new lease?
Yeah.
Well, if they modify the lease, and there's a new lease, isn't there? Right. I mean, if the landlord just decides, not to cash a rent check or to give a refund, that's fine. But if he actually wants to lower the rent, and that requires a creation of a new lease. And under the new lease, I'm sure they would negotiate whatever terms are necessary to provide for the fixing of the leaks. The other answer is, it says here you can't reduce the rent right here. But had they sued in court, the court may have said, okay, you know what? If you want to stay here, you have to reduce the rent or fix it. And that would probably be the decision of a court. Yeah.
In the book, it said for actual eviction, it has to be a material part of the lease premises. So, like, for example, if there would have been like a broom closet that they never used, it wouldn't have been considered an actual eviction.
I could see a court going either way in the broom closet. I mean, you got to sweep up all that water, right? I mean, there's a lot of water in this place.
So, and would it be fair then to say anything that's inside of the building would be material because it could lead to damage? And it almost seems redundant.
I think most if for whatever reason, I mean, imagine the situation. Let's say the landlord said, you know what, that broom closet I need to use for storage. I'm gonna put my stuff in there. At that point, the tenant does not even have access to his own property. I think he could probably claim at least a partial eviction. But the material part, I think that's it's the eye of the beholder, right? Because if he really needs that broom closet, then he can use it. Questions? All right. So as this discussion has made clear, the line between constructive and actual eviction, and I think a couple of your questions were touching that as well, can be awfully very close. And these often become very contested, disputed facts. Unsurprisingly, landlords and tenants often don't agree on those facts. And this becomes a fairly rigorous issue for the courts to try to resolve. It's a game of he said, she said, like, oh, he said this. Oh, no, he actually said this. And these things are often not written down, the oral statements that are given. But because in this case, the court said they were deprived of a material part of their lease, there was an eviction. Okay. All right, so questions on the case? Yeah, Hunter?
The prosecutor's office have wanted, they've sued for any price difference in the new place they had to move to because of the wrongful eviction.
So, I mean, the lease says to recover for damages, right? And, I mean, my quick reading of that is the actual damages to the property, not the damages moved somewhere else. Although I could imagine a crafty lawyer could interpret that in such a way to say the damages are moving elsewhere. In this case, the damages include destruction of evidence, which is incalculable. I don't know how you put a price tag on that. So I'm not even sure how that would work. I suppose you could say the damages for any loss resulting from the breach or the damages move elsewhere. I think you could probably make that argument, although it probably wasn't exactly what the landlord had in mind. It was more like, imagine if, some plaster fell off the ceiling and you had to hire a cleaning crew to remove it. I'm guessing that's what they considered, not having to move elsewhere. But I think you could probably make that argument. Okay. Questions on the case? All right. So the book discusses also the sorts of common law rules. Under the common law, which is not really in effect anywhere anymore, there was not really any duty to provide any sort of guarantee of the conditions of the property. The only things that you had to disclose, right, was the actual legal title. You have to just get the legal title, and that's it. Even under the common law, you weren't even required to notify the person their defects. If the person asked about it, you couldn't lie, but you had to hope the person didn't ask. Modern day leases don't have that sort of problem. I'm sure as all of you have signed leases, there's like 30 or 40 various check boxes. Is there lead? No. Is there this? No. Is there that? No. The purpose of this is to prevent the landlord from withholding any information that may be material for you to know. And by making them check off and sign every single conceivable problem with a lease, at that point, there's really not much information that can be withheld. Okay. Also, under the modern approach, under the not common law, maybe to this is a Jamie's broom closet example. There's something called a partial eviction. A partial eviction is where you can't access part of it. And this is something that probably is in the lease itself, but the courts may read into it, where the courts may actually say, okay, you know what, you can't use that rent closet. That rent closet, the broom closet is 15 square feet. We're going to reduce your rent by that many square feet. So that's, rather than terminating the entire lease, some modern approach has said we'll just reduce the rent for whatever part you can't access. So even under that approach, it's conceivable that the fact they couldn't use, this one room, the court could have set it off. Although that's probably not the best approach for this sort of commercial lease where they were trying to use a lot of it. And I don't know that the partial eviction is too common, but the book does recognize its existence.
Is it under common law?
No, that's a modern approach. Yeah, I mean, it's not. It's going to be rare where that's the issue, because generally the idea is you have access to your entire property. But if it's not material, that was Jamie's example, the broom closet, that may actually fit in there. Good example, broom closet. I got to use that one for next year. Thank you. Okay, questions on that? Okay. All right. That's all I really have is a fairly short lesson. Unless you have anything else, I can let you guys out early. All right. Enjoy your rest of your day. Thank you. I'll see you all on Tuesday.
It's